I want to start by thanking Chairman Nadler for holding this urgently needed hearing today. And I offer my thanks to all of the witnesses for their thoughtfulness and for their time. As I read through Justice Thomas's concurring opinion in Dobbs, I think of the heads up he gave us about the far-right majority's plan to overturn other well-established constitutional rights that Americans had just taken for granted in their daily lives. In particular, Justice Thomas calls on the court to, quote, reconsider all of this court's substantive due process precedents, including the court's 1965 decision in Griswold, as well as the court's decisions in Lawrence v. Texas and Obergefell. These are, of course, the three cases establishing the constitutional rights to contraception, non-procreative intimacy, and marriage equality. In casting doubt on these decisions, Justice Thomas let us know that the far-right majority on the court is not satisfied to have deprived millions of Americans of the right to an abortion. Rather, the majority is on a rampage against other freedoms currently enjoyed by the American people. As someone who has repeatedly drawn attention to the partisanship of the far-right majority on the court and the fact that these 6 justices are not people who can simply be reasoned with using sound legal arguments or even the court's own precedents, I can't help but think of Justice Thomas's glaring omission of another case, and this has been discussed to some extent today. That case is a 1967 decision called Loving v. Virginia, which established the constitutional right to interracial marriage. It seems to me that following Justice Thomas's logic about reconsidering the court's substantive due process precedents, the Loving decision would fall naturally on his list. In fact, the Supreme Court's 1973 decision in Roe v. Wade explicitly relied on the decision in Loving v. Virginia. Moreover, the case is cited multiple times in both Justice Alito's majority opinion and in the dissent in Dobbs. Now, my Republican colleagues would say that Justice Thomas's omission of Loving v. Virginia is nothing at all to do with the fact that he's a black man married to a white woman. Never mind that he tried to block the January 6th committee from seeing documents that may have included evidence of his wife plotting the insurrection at the Capitol. He would never do something that is in his personal interest above that of what the law requires or sound legal reasoning requires. Professor Murray, what does it say to the reputation of the Supreme Court, or what does it do to the reputation of the Supreme Court and to people's faith in the institution that justices like Clarence Thomas appear to be deciding cases based on their own personal preferences and political ideology rather than what the law requires?
Thank you, Representative Jones. I will note that this idea that judges deciding cases based on their own predilections is the very essence of the judicial activism that your conservative colleagues have denounced. I also wanted to respond to Representative Owens's comments about condescending racism. I would like to perhaps call attention to the condescending sexism of this decision, which seems to view the choices of women as somehow illegitimate when they make them. The Supreme Court has virtually ignored American women with this decision, and the consequences will be startling and alarming.
Thank you, Professor. A Gallup poll released on the day before the Dobbs decision revealed that 75% of Americans do not view the court as a legitimate, nonpartisan institution. Confidence in the court is vanishingly low for good reason. The question is, what the hell is Congress going to do about it? And it turns out we are not powerless to stop this court's rampage against our freedoms. Congress, in fact, has a breathtaking number of options to rein in the power of this rogue Supreme Court. In the past, Congress has deprived the court of appellate jurisdiction to issue certain decisions. It has expanded and contracted the number of justices. It has granted and withheld the court's power to issue injunctions and other writs. It has immunized particular types of defendants and executive actions from judicial review. It has suspended causes of action to bring certain challenges. And of course, it has taken other actions. I have routinely urged this body to take action to reform the Supreme Court. Action that is desperately needed to meet this moment in our history. It's why I introduced, along with Chairman Johnson and Chairman Nadler, the Judiciary Act to add 4 seats to the Supreme Court of the United States. And additionally, I recently proposed an amendment to the Women's Health Protection Act that would strip the Supreme Court of its jurisdiction to review that very legislation and channel all review of its constitutionality and legality to the D.C. Circuit Court of Appeals. Interestingly enough, the conservatives on the court, specifically Justice Roberts and Justice Thomas, have long endorsed Congress's ability to do these things. We are at an inflection point, and years from now, history will record this as the moment when we decided what we would do to defeat the threat of fascism in this country posed by the modern-day Republican Party with the Supreme Court of the United States as an accomplice. I yield back. And the chair now recognizes